Good afternoon, sir.
Good afternoon.
Uh,
Give your introduction.
First of all, thank you so much, sir, giving me this beautiful opportunity to explain myself. Sir, my name is Poonam Jagarwal. I'm from the Karori district of Rajasthan. I did my 10th and 10th plus 2 from the Basra district government school and BA LLB from the Jaipur National University, Jaipur, and Masters in Constitutional Law from the University of Rajasthan. This is my fifth attempt and third interview. Sir, in would I like to add that recently, 2 years back, I donated my hairs for the cancer patients.
Okay. What does your name means?
Sir, Poonam name means the full moon. The in Hindi it called Purnima.
Purnima. Okay. Why do you want to be a judge?
Uh, Sir, I've taken the inspiration from my grandfather's life. When I was younger, I saw him. He was decide the dispute between the peoples at the grassroots level. He is not a judicial officer, but he is a sarpanch of the village. So he decided the dispute. And after when I become a mature, I decided to do the law and become a judicial officer.
Okay. Do you read the newspaper?
Not that much, sir.
Okay. What is the difference between bar and bench?
Uh, Bench and bar. I'm not sure about that, sir.
Okay. What is the difference between common intention and similar intention?
As common intention defined under Section 34 of the Indian Penal Code, where the several person does any act with the furtherance of the common intention, and each and everyone is liable for the single act as he done by alone. That is defined. And the similar intention where the person do not have a pre-meeting of mind, but they have a similar intention as 35 of the Indian Penal Code. For the 34, we can go for the Mehboob Shah Emperor versus case. There is a guidelines propounded by the Privy Council that pre-meeting of mind and pre-meeting of mind is required for the common intention.
Okay. I have a proposition for you. Suppose your watch has been stolen. You
Yes,
see
sir.
a person bearing a watch in his hand.
Yes, sir.
Will you snatch the watch from him?
Uh, when I saw my watch in that person who is carrying, and that property is belongs to me, but how I will identify? Because as we can know, the similar watches is available in the
No,
markets,
it's
and in is it?
matlab, suppose that watch belonged to you. You identified.
I will. Sir, it's. I think I will not snatch because snatching is another kind of offense. I can take legally and with rightful meaning, not in that way to snatching and.
So then what remedies you have?
Uh, I will before going to legal approach, I will go and I will request to him how, and I will ask whether how he got this watch. If he describe the source of the from where he purchased, then as per the procedure of the CRPC, there is one section which describes if you find out your property with someone and he is an innocent purchaser, then the innocent purchaser will get the proper money from the person from whom he purchased, and I will take my property from him.
Which
That
section
kind
of
of procedure is
CRPC?
there.
Which section of CRPC?
Uh, I'm not that much aware, but I think that is section 454 of CRPC. I'm not sure about that, sir.
Okay. Can a juvenile be kept in jail?
Uh, Juvenile, if he is committed a serious or heinous offenses as described, and he is above the 16 year of age, and it is proved that his mental ability is there to understand the consequences of the judgment of what offense he has committed. then but we cannot keep him in a jail. In place of, we will keep in a place of safety or children's home, or in that place we will keep, not in a jail. After 21 years of completion of age, we will shift to him jail.
Okay. Suppose a senior police officer,
Yes, sir.
suppose a senior police officer demands detention of accused in police custody
Yes,
after
sir.
the expiry of first 15 days. In a
Yes, sir.
case where some more serious offense has been discovered to be committed by the accused in the same transaction,
Yes,
whether
sir.
he is justified in asking for more police remand.
As we go for the provision of the legally, he cannot demand for the further police custody, because first of all, it is clearly mentioned under section 167 of the CRPC that first 15 days is only the possible for the police custody. After that, only the judicial custody is the legal, and we have to be see the rights of the prisoner accused also. So in case police custody will not be allowed to him.
Okay. Can session court grant anticipatory transit anticipatory bail?
As according to section 438 of the CRPC, the session court have also power to grant the anticipatory bail.
Yes, my question is, can session court has power to grant transit anticipatory bail?
Transit anticipatory bail, yeah, I think so. I'm not sure, but yes, there is a provision, and the Court of Session will grant the transit. That words, I think there is a written is that anticipatory bail. If and as I heard, that transitory bail and anticipatory bail have a same meaning. So in that case, the Court of Session have a power to grant the transitory bail to accused.
Is there any judgment on this point?
Uh, in that point, I don't remember that judgment, but I remember one judgment. There is clearly told the Supreme Court that bail is a right and jail is an exception. That is a Moti Das versus State of MP something, sir.
Okay. Tell me, what is contract?
Contract is a agreement which is enforceable by law between the parties, sir, as defined under the Contract Act.
Okay. Uh, Give me some example of invitation to offer.
Invitation of offers, when the shopkeeper showing some products outside their shop, that is an invitation to offer. When the person will go to when the buyer will go to shop and pick the product from their shop, it is offered to a seller that this is I want to buy. Now it's a choice of by seller to whether he want to sell it or not. That is an invitation offer to showing the product outside the or displaying the products to attract the customers or call the customers.
Okay. Can a witness be compelled to answer question which may entrap him in an offense?
No, sir. Witness will not be compelled to answer as provided under the Indian Evidence Act, Section 132, 131, I think. Yes.
Okay. What is difference between expert and ocular evidence?
So I know the expert. Expert means the person who is special skill or special knowledge in particular subject. For example, we have a expert who will give the expert opinion as provided under the Section 45 of the Indian Evidence Act: fingerprint, handwriting, science, art, and foreign law. But that other term of I'm not familiar with that, so I will not. I'm not able to explain that.
Okay, no problem. What is a protest petition?
Please pardon, sir.
What is a protest petition?
Pardon, sir. I really don't.
Okay. Does res judicata apply to bail application?
Uh, no, sir. Res judicata will not apply on the bail petition.
Why?
So, bail as provided that it is a right whenever the and bail is applicable in the criminal cases and res judicata applicable in the civil cases.
Okay. Tell me, can accused become a witness in his own case?
Accused will be witness or in his own case if we accept the tender of pardon when with the accumulated with others accused, he will be the witness in his own cases. But there is a provision in the Indian contract in Constitution of India that witness cannot be means the self-incrimination is a violation of the Article 20 of the Constitution.
Okay. Suppose a plaintiff give notice under Section 80 of CPC and institute a suit before
Yes,
2 months,
yes, sir.
but suit is allowed to withdraw the same with the liberty to file a fresh suit. Is he entitled to file a fresh suit without a fresh notice?
Yeah, I'm not familiar, sir, with that provision. I'm not sure.
Okay. What is the original jurisdiction?
Judicial jurisdiction, as provided under Article 131 of the Indian Constitution Act, where the court have a power to decide the dispute and to heard the dispute between the union and the state or state versus state or any such. Correct.
Okay. Suppose
Yes,
A
sir.
who was hit by a bullet stated in the hospital in the presence of a magistrate that B fired at him,
Okay.
but A did not die of this injury.
Yes, sir.
Is the statement of A made in the presence of magistrate admissible in evidence against B?
So this statement is admissible, but require the corroboration and the contradict with the other statement under Section 157 when the statement made under Section 32 and the person who not died, that should be a formal statement and it should be considered as a evidence when it is made.
Can this statement treated as dying declaration?
Uh, no, sir. Statement is only treated when the person will not be in existence, and after giving the statement, he will be not in the means he died. Then only this statement will be treated as a dying declaration.
No, as per my question, A did not die of this injury, means A dead. A died, but not this injury.
Okay.
Then,
no, sir. This statement is also be not considered as a dying declaration because the reason of which his death is happened, that statement only relevant to that. Other injury not be considered as a dying declaration for that.
okay, okay, right. What is the difference between set off and counterclaim?
Set off as provided order 8, rule 6, where the pecuniary jurisdiction, same subject matter, and the between the same parties, and it should be related to the money suit. That is only the set off is will be possible, and the counterclaim when the defendant claiming set off and the counterclaim is a kind of same nature and provided on the order 8 only, and the counterclaim is a same where the defendant claim against the plaintiff the pecuniary amount. That is counterclaim, sir.
Okay. What is ex parte decree?
Ex parte decree, when the uh, defendant will not appear on the date of hearing, and uh, then court pass the decree in favor of the plaintiff. That is called the ex parte decree, and it is not defined in the CPC, sir.
Okay. What do you understand by interpleader suit?
Interpleader suit, when as provided in the 88 of the CPC, when the plaintiff does not have any interest in the subject matter or the suit except the charge and cost, and the suit and he filed the suit against the defendant, and there is a two defendants to whom the property he should be transferred. The rightful claimant, he is asking to whom I will transfer this property. That is an interpreter. So for the to identify the real owner or the real claimant, if the plaintiff filed the suit before the court, sir.
Okay. Whether the life of anticipatory bail should end at the time and stage when the accused is summoned by the court.
Uh,
What is the
anticipatory
life of
bail.
the anticipatory bail?
Anticipatory bail is so I'm not sure about the life, but when the anticipatory bail is granted, that is before the before the intimation of his arrest, or he have he have the knowledge that I will be arrested in some crime, so he take the anticipatory bail before the court, and with the and there is a condition also whenever we call you, you have to be present before the court. It means he will not keep in the prison, only he will appear the hearing or hearing of the court. So and so I'm not familiar with the time period, okay, for how many days it will be granted. There is a no specific time mentioned in the CRPC as my knowledge, sir.
Okay. Whether the statement recorded by the investigating officer under NDPS Act treated as a confession.
NDPS subject is not of my knowledge, so I really don't know whether it is treated as a confession or not.
Okay. Can a child of void marriage become co-partner? Can a child
Sure.
become co-partner in Hindu joint family?
Sorry, sir. I really don't have idea about.
Okay. Tell me, what is the difference between the judicial order by magistrate under section 156 and 159?
Under section 156 and
56
159,
and 159 of CRPC.
so section 156 deal about the investigation. Police will investigate in the cognizable cases, and 159 is the submission of the report to magistrate. It deals with that section. And what is the judicial order? I'm not well aware about that.
Okay. Tell me whether the police officer need to take permission of the judicial magistrate in order to continue to further investigation after filing police report.
Yes, sir. As the section 173 clause 8, he can take the further investigation if he feel there is some matter or some possibility is there, or some investigation is required. In that case, he will make the further investigations.
Okay. Then tell me, what will you do if you are not selected?
So I will do again my preparation. Means I will continue with my preparation because I want to fulfill my dreams, and let's next option, whatever I will get, I will
What
do
will you
that
do
also.
if
But
you are not selected again?
till so there is a bar of age till the my age. When I not cross that age, I will try to get uh, clear that exam.
Okay. Okay. Thank you.
Thank you, sir.